we're going to be getting started in just about a minute.
Thank you, everyone. It's been since February of 2020 since this court has gathered in person to hear cases. I certainly thank our IT staff that allowed us to continue with the process of rendering justice despite the challenges of a pandemic like none that any of us have ever seen. And today, for the first time ever, we are having this in-person argument, but it is being live streamed. So I think it's an access to justice issue, and I'm so grateful for our IT staff and their ability to help us to stream this so any person in North Carolina, the United States, around the world can watch our courts as we seek to do justice. So that being said, it's my privilege to call our first case this morning in re C.B.C.B, and we will hear from the appellant.
May it please the court, my name is Robert Ewing. I'm with the Forsyth County Bar. Just as housekeeping notes, I would just request that I have 5-minute rebuttal time. I represent the respondent mother in this case. This is a juvenile case, so I'll be using pseudonyms to protect the identity of the child. In this case, the respondent mother gave birth to a son, Charlie, who was born on August 15th, 2019. When Charlie was born, DSS received a report concerning Charlie's safety due to my client's past criminal record and her prior history with DSS concerning the murder of her son, John, as well as the abuse and neglect of John's sister, Kate. There was an adjudication in regards to Kate, a juvenile adjudication, where she was found to be an abused and neglected child, and the court made findings of fact surrounding the death of John and the abuse and neglect of Kate. Once a social worker got the report on the day that Charlie was born, she went to the hospital the next day and met with my client. She reviewed the adjudication order back from 2013 regarding Kate that also included the facts concerning John's death. The adjudication order found that John died on May 3rd of 2013 while in the custody of my client's boyfriend while she was at work. The boyfriend was the sole caretaker of John when he passed away. On May 3rd, law enforcement was called out to her residence. The boyfriend had attempted to contact a neighbor to call 911. John was not responsive and had died on the scenes. He had injuries, including second-degree burns and scabs to his forehead, back, and buttocks, bruising to his forehead. He also had sustained bruising to his face. He had rib healing fractures. When investigating the case, 7 to 10 days prior, both John and Kate had suffered extensive scalding injuries while in the boyfriend's care. And the court found that they were intentional injuries. Neither my client or the boyfriend sought medical care for these injuries. In addition, the court found that my client canceled a visitation with her mother to conceal the injuries. An autopsy was performed, and the presumed cause of death was determined to be drowning, with the significant contributing factors of burns and blunt force injuries. There was a finding that the boyfriend said that he was trying to give a bath to the child and left the child unattended. The 2013 adjudication order found that Kate was an abused and neglected child because of the injuries that were abuse. There were also other findings that a child was strapped, or children were put in car seats and left in dark closets for significant periods of time. In the findings, it found that my client stated to the court that her boyfriend was becoming overly aggressive during the last several months of their relationship prior to John's death, that she was afraid of her boyfriend. She saw her boyfriend hit the children with a double loop belt, hit the children on their buttocks with an open hand. Even though that she saw this overly aggressive behavior, she continued to leave the children in his care. But the court did find that Wendy was afraid of her boyfriend, that she wanted to leave. She spoke to her friends about leaving, and that she was a victim of domestic violence. At the termination hearing, Wendy testified she attempted to call law enforcement, but when she attempted to do that, her boyfriend threatened to kill her and her parents, that he possessed an AR-15. She also noted an incident where her boyfriend crushed her cell phone, which was trying to message her mother.
Was any of this information included in the trial court's findings, Mr. Ewing, in the termination order?
Well, yes. The details were not. But the court found that, she reported that she was a victim of domestic violence, that she tried to move and just didn't do it.
Well, the court finds in finding of fact number 13, at least, that respondent mother knew or should have known of the extreme risk posed by the boyfriend and took no steps to prevent the injury of the children and the death of the son.
Correct.
So, I mean, the testimony that you've been reciting, I'm not sure is consistent with that finding, is it?
It is. Under a 7B-A8 ground.
Okay, if it is, help me. I guess the implicit question was help me understand why you say what you say.
Right. Under 7B-A8, just take a step back. I'm going to answer your question.
Sure.
If a parent commits murder or voluntary manslaughter of a child, that is a ground to terminate.
Right.
Also, the legislature has put forth other ways, aiding and abetting, solicitation, attempt. For aiding and abetting, you are a participant in the crime. You're participating, you're helping out in the actual crime as it goes. And so, knew or should have known of the extreme risk, first of all, that's not the standard for aiding and abetting. You're aiding and abetting a crime. It's not something that's foreseeable. Also, where you're looking at it is, the picture that's being drawn is that my client consented to this. And so the issue of domestic violence, of the pressure in the home, is significant.
I understand that there was an evidentiary dispute about that particular question at the termination hearing. I guess what I'm trying to make sure I understand is the trial court found that your client aided and abetted in the murder of the son. Standard for aiding and abetting is that the defendant knowingly advised, instigated, encouraged, procured, or aided the other person.
Yes.
What your argument before us essentially is that the trial court's findings don't support the aiding and abetting determination, if I understand your argument correctly, and if I don't, please tell me.
That is correct. I also thought they used the wrong standard, but to answer your question, yes.
But I mean, I think that I guess what I'm trying to understand is, given the recitation that you were making when I interrupted you,
You're fine.
What is it about the trial court's findings that compels a determination that there was no knowing advice, instigation, encouragement, procurement, or aiding?
There was no finding that she knew that her boyfriend was going to murder her son the next day or that morning when she left him for work. So she had no knowledge. There was no finding that they had a discussion about this.
I mean, my understanding of your colleague's argument is that the knowledge can be inferred from the other findings, assuming that that's their argument. What would be your response to it?
Well, you can't be,
I'm sorry?
well, I guess the way the court said knew or should have known. So
Right.
should have known is not knowledge. And in addition, it didn't say knew or should have known of murder. It said knew or should have known of an extreme risk. So even by the court's own findings, they're showing that she didn't know that this was going to occur that morning.
How are we to reconcile your position that the mother's omissions or commissions did not rise to a level to invoke 7B-1111A8 with the affirmative duty of a parent to protect the well-being of a juvenile?
A8 is very specific, right, on the crimes that are listed. So to terminate just on that ground, the court has to show by its findings that she aided and abetted in the murder.
But there is also the affirmative duty of a parent to act in accordance with the well-being of a child, and yet your position is that because there was no knowledge of, as you say, what the killer of John was doing, that somehow there was not the affirmative duty of her to act. So where do we reconcile A8 with that affirmative duty?
When you're looking at it, she pled guilty to intentional child abuse, serious injury, and I think 4 counts of negligence, child abuse, serious injury.
5, but yes,
Yeah, total, right?
yes.
Total 5, but 1 was intentional, 4 was negligent. Does that mean she's automatically guilty of murder? Did she aid and abet? Did she participate in this murder? I mean, that's what aid or abetter does, right? They're participating in the crime. They may not do all the elements of the crime. And so the argument is that you don't have the findings showing that she actually participated in this murder.
So is it your position then that there is no need for us as a court to reconcile what may be appearing to be what I'm hearing is a less than affirmative duty on the mother to act because she was not aware, according to your depiction, as to what was going on in her absence?
She has an affirmative duty, but does that make her guilty of murder?
But as to aiding and abetting, you're saying that it falls short even of that level of culpability?
Yeah, well, if you have knowledge, or let's use the case that, the Walden case, which is what the court seemed to base their conclusion on. In that case, the mother was present with the father while the father was assaulting the child. And the mother was at home when this happened and didn't stop it. She was there. She was present. She knew what was going on. She knew the event. She knew the assault was happening. And the duty takes place there. This is a different case because she's not even there. And there's no findings that she knew he was going to do that.
What would be your response to why you say she was not there, that there was some activity on her part, as it was at least discerned, to hide the injuries by canceling the dinner with the guests that were coming in order to make sure that there was no recognition on the guest's part that there was this injury and treatment of the child?
Ultimately, it doesn't show that she had knowledge of that crime, which is the standard. But I think we're using a theory called accessory before the fact, that she did something before the crime, she wasn't present. But that's not one of the enumerated theories in 7B-A8, nor did the court find that she was an accessory before the fact. Even then, I don't think she's accessory before the fact because she didn't know what was going to happen that morning.
Well, isn't the language in Walden fairly broad in terms of the extent of the duty of a parent to take affirmative action?
It is broad there, but if you read the Walden opinion, they said they made their decision solely on the fact that the mother was present.
Well, and it says that, but after Walden, with the enactment of 14-5.2, the necessity for presence was done away with respect to aiding and abetting by statute. Is it your contention that the presence rule that you're deriving from Walden survives the enactment of that statute?
No.
So what do we, because you've emphasized in your brief and you emphasized in your response to Justice Hudson the fact that your client wasn't present, given 14-5.2, what relevance does the presence or absence of your mother, of the mother at the actual time of death have?
Let's look at Walden when it was done. Your presence was required.
Right.
Then there was a rule that's still in effect that says that your mere presence at the scene of a crime is not enough to show aiding and abetting.
Well, given that there was no presence, there's no evidence of presence at the time of death, how does that rule have any application here?
I don't think it has an application to aiding and abetting,
Okay.
at least under these facts.
Well, so what are we supposed to, are you arguing then that in the absence of a showing of prejudice, you can't have aiding and abetting on the basis of the rule in Walden?
I think it is probably possible.
So what are you asking us to hold in this?
Well, it's knowledge, but it's also like the Claypool case, which the Claypool case is actually accessory before the fact case as well. But Claypool, the mother in that case, her daughters, she had 2 children from a previous marriage. She remarries. The new father starts acting sexually inappropriate with the kids and starts having sex with the kids. He impregnates one of the kids. So and the daughter goes to mother and says, I'm having sex, I'm pregnant. Sick facts, but the mother says, okay, if it feels good, do it. And she said in West Virginia, apparently this is how you groomed your daughters, and it means bad facts. She's sitting there actively saying, not only I know about it, but I approve of it and I want you to do it. You don't have that in this case. You have no findings showing that she wanted her boyfriend to kill her child the next morning or the next day while she was at work.
I would like to ask you about another of the enumerated crimes in 7B1111A8, because it also says, has committed a felony assault that results in serious bodily injury to the child, another child of the parent, or another child residing in the home. And isn't your client's plea of guilty to intentional child abuse a felony assault that results in serious bodily injury?
It doesn't have to be.
But in this case, she did plead guilty, and the statute goes on to say that you can prove that by proving a conviction, a proof that a court of competent jurisdiction has convicted the parent of the offense, whether or the conviction was by way of jury verdict or any kind of plea. And so here, where your client has pled guilty to intentional child abuse afflicting serious injury, why doesn't that just end the inquiry? That allegation that she was convicted of offense was in the petition, that allegation was in the trial court's order terminating parental rights. Why isn't that enough to satisfy the statute?
Because you don't know if the intentional child abuse was an assault by her.
Isn't an element of intentional child abuse inflicting serious injury that there's an assault?
Was inflicting serious injury.
Which is what she pled guilty to.
Inflicting a serious injury, yes. Doesn't mean she assaulted the child.
So you're saying that assault is not an element of intentional child abuse inflicting serious injury?
It can be, it doesn't have to be. See, in this case, you know, the kids were placed into the car child seats for hours at end.
But isn't the trial court allowed to, in examining the record, understand that while it doesn't have to be an element of the offense in an academic sense, that in this sense, in this case, that serious injury came about by virtue of a physical assault? Thereby, as my learned colleague Justice Earls was saying, therefore, proves an element of the offense.
The answer is could. It's any factual, you could do that, but that's not what the court did here. The court didn't find that she was guilty, didn't terminate her A8 for felony assault. So under its conclusions under A8, the ultimate conclusion was respondent mother has aided, abetted, attempted, conspired, or solicited to commit murder or voluntary manslaughter of another child. And then cites Walden. So the court didn't find that she assaulted the child. Or didn't conclude she assaulted the child or was guilty of that offense. So based on the findings we have, is it a realm of possibility there's a set of facts that say that she assaulted somebody? You know, that's definitely a ground, but that's not what happened here.
Well, let's assume that we were satisfied, contrary to your argument, that the assault ground that Justice Earls asked you about was supported by the findings, but that the trial court's conclusions don't make any reference to it. What are we supposed to do then, in your view?
Well, the court didn't find the assault, so it should be reversed. It could have found. I don't think it could have found, but it had the opportunity to find and did not find.
Would it be appropriate to remand instead of reverse in the event that we were persuaded by your argument that there was the findings didn't support aiding and abetting murder, but that there was evidence in the record from which finding of A8 on the basis of felony assault involving serious bodily injury occurred?
I mean, the court was presented with it.
I'm sorry?
The court was presented with the evidence, and the court didn't find that she assaulted either child. It didn't make that finding. And in fact, you can see the court's rationale that she knew or should have known of the extreme risk the boyfriend has. The court seems to indicate that the boyfriend is responsible for the injuries.
So what do you contend is remaining of the affirmative duty to act to prevent harm to one's child if you know that there's an extreme danger, but you don't know precisely what or when it's going to happen?
There is that duty. I don't know if there's,
What does that mean, the parent is supposed to do, in your view?
well, certainly she was convicted of intentional child abuse. So you have that there. Are we saying that she committed a murder, second-degree murder? I mean, where do you, this is the scary part about this is if you say that this is the standard, a parent should have knew or should have known of an extreme risk. I mean, the gambit of things that could happen are huge. You put a child on a whitewater rafting trip. There's a risk you can drown. You sign a waiver saying stuff before you go on one of those things. But for aiding and abetting, you are a participant in that crime. You are participating, and there's just simply no evidence you participated in the murder.
So, for example, there could be a duty to, if you know that a person who's a potential caregiver of the child poses an extreme risk of harm to that child, that you take affirmative action to not put the child in the custody of that person. Is that reasonable?
It is reasonable, but under law, does that make you guilty of murder?
Well, no, my question is, where's the duty of the parent?
Well, certainly she had a duty here. I mean, she had a duty to her children. I'm not trying to say she doesn't.
But to do what?
To protect her children. I mean, that's just, there's a duty there. But what is, what is being covered? And so,
Is there anything in the evidence that she did, or any findings that she did anything to carry out that duty?
there what, the only things that I can say is that she attempted to leave, and she discussed with her friends trying to leave that relationship.
But that's the only thing in the evidence that could fit within the category of taking some sort of affirmative action?
I think, based on the record.
Okay.
Well, to go back to the question that I asked you at the very beginning, in finding of fact number 65 in this quotation from the earlier order, which is part of finding of fact number 6, it says, mother had opportunities to seek assistance and protection for herself and her children from the boyfriend. If she was in fact in fear of him, she had experience obtaining domestic violence protection orders and the services available to victims of domestic violence, et cetera, et cetera. I'm not going to read the whole thing in the interest of time because I know I'm cutting into your rebuttal. But you keep emphasizing this evidence that the mother attempted to do these various things to leave, but the trial, I can't find any indication the trial court found that she made these attempts or gave her any credit for doing so.
See, a finding of fact number 6.
63, 65, which appears on page 499 of the record, I believe.
Well, on 504 and 505,
That's from the quotation from the earlier order. 63 is the quotation from is the finding in the earlier order.
let's see. There was a finding, though, I believe, that she was attempting to leave.
You've got.
How about number 499, number 57? It says Whitney Weathers admitted that, excuse me, please beep that out. The respondent mother admitted that she had seen the boyfriend increasingly aggressive the last several months. She stated she was afraid of the boyfriend and wanted to leave him, had spoken to friends about leaving him but did not act on that. She admitted at least seen him hit the child.
It's a finding that she stated, but not a finding that that testimony is actually true.
Well, yes,
Okay. Thank you.
you're welcome.
Thank you. We'll hear from the appellee.
May it please the court, I'm Lauren Vaughn. I represent the Catawba County Department of Social Services, one of the appellees in this case. I'll be dividing my time today with Matt Wunsch, who represents the Guardian Ad Litem program, and we plan to divide our time about evenly. I think it's important that this case be affirmed because to do otherwise would strip 7B 1111A8 of a significant portion of its meaning. It would strip any real teeth away from the aiding and abetting portion of that statute. And also because it's good public policy and important public policy that the parental duty to protect one's children's safety and welfare be strongly upheld by this court. I plan to address 3 points. Of course, I'll address whichever points you all want me to address, but my plan is to talk a little bit about the affirmative duty under Walden that was established there, and then the impact of 14-5.2 on that liability. It is, that affirmative duty. It is our argument that 14-5.2 in fact expands the parental duty that was established by Walden. And then finally, to talk a little bit about the specific ways and the specific findings of the trial court that show that the respondent mother in this case failed to meet her affirmative duty. And so I think one thing that's important to remember as far as the facts of this case is that this child did not die because of a single act of abuse that happened on May the 3rd of 2013. This child died because of a course of conduct that was set in motion at least 7 to 10 days prior, of which the mother was a participant ongoing. The record and the findings of the court show that she agreed and participated in acts like putting these two children in a dark closet with no light on, strapped in car seats, shoving things in front of the door, and leaving with her boyfriend to go to a bar. That's the conduct that her boyfriend understood was acceptable to this mother. And after that, about 7 to 10 days prior to the death of this child, she came home and found these extensive scalding injuries on her children. Second-degree burns covering significant portions of their body. The findings of the trial court say that the explanation the appellant cites that happened when the boyfriend left the child unattended in a bathtub, the trial court found that was completely uncredible. The trial court heard medical evidence and medical experts saying that's not the pattern of these scaldings. They were intentional. She came home and found that to be the condition of her children, and she continued to leave her children with the boyfriend. Again, showing him this is acceptable behavior. This is an acceptable way for you to treat my children. She then would come home repeatedly and find bruises on her children, still doing nothing. The trial court said that she had witnessed him whipping the child, that she had participated in that somewhat.
Are we allowed to go as far as you would have us to go if, in fact, the ruling of the death of John as to the cause was drowning, and that what you are saying were deemed to be contributing factors?
Well, it would be my contention that the contributing factors are very important because it placed this child in a condition that he was that much more susceptible to whatever caused his death on that day. The findings of the court and the testimony was that when the mother left him on that morning, he was lying on a sofa, basically lifeless. That was the result of what had been going on for those 7 days ahead of time. He was barely eating. He was very weak. The mother testified that although he had been an active toddler before that, she wasn't worried about leaving a 19-month-old child lying on a sofa because she knew that he couldn't get up and move anymore.
But as to aiding and abetting second-degree murder, are we allowed, as you would have us to go, to say that the bruising and the treatment of the child, John, with the scalding and being placed in the closet with no lights and strapped to the car seat and all of that, while it may have been contributing as was officially designated, are we empowered to say that those amounted to aiding and abetting a drowning?
I believe that you are, Justice Morgan, because I'll call your attention to State v. Reffin, which says that if a principal who is assisted by the defendant to commit a crime commits a different crime from the crime counseled by the defendant or consented to and contributed to by the defendant, as long as it is the natural consequence of the original crime, then they can be held liable for aiding and abetting in that crime. So I think it was completely evident that the mother was aiding in the ongoing abuse of her children. And when she left that day, she was at least consenting to and aiding and providing the opportunity for her boyfriend to abuse her children. And given the fact that she left this child in the condition that she left this child, knowing what she knew, then it was a natural consequence of that ongoing abuse that if he continued to be abused, that he would die. And so I believe that you are allowed to go that much further and find that she did aid and abet in that murder.
Can I ask you about one of the court's findings? This is page 499 of the record. The court is quoting here from an earlier order that it is, from findings of fact that it is incorporating. And so finding fact 62, the court specifically finds that both of the minor children have been struck on multiple occasions by Mr. Lale and or Ms. Weathers with objects including not limited to a belt and a coat hanger. What can we make of that finding given the and or language?
Well, I think that she is guilty of aiding and abetting in this murder, whether or not she actually assaulted the children. Because again, she continued to create that opportunity for them to be abused and to consent to that treatment of her children, to keep him from being discovered in his abuse of her children by authorities, as I believe someone referenced earlier, her not taking them for medical treatment, her canceling the get together with her parents and that sort of thing. So all of those acts, she was aiding and abetting. Whether or not she actually ever struck the children, I still believe that and would argue that all of those other actions constitute aiding and abetting.
Well, let me ask you a related question, which also goes to some of the language in the trial court's order that Mr. Ewing pointed out about there. We do have a requirement for aiding and abetting that there be knowing aiding and abetting. The trial court repeatedly says knew or should have known. State versus Boone says that under North Carolina law, should have known isn't good enough, that it's got to be known.
Yes.
Given the fact that the trial court repeatedly found should have known, why is that not a basis for at least requiring that this order be remanded to the trial court for determination of whether you had actual knowledge or not?
Well, I think that the extensive findings regarding the circumstances are sufficient to show that her knowledge can be...
They may be sufficient, but we're not the finder of fact. It's the trial court.
Yes.
And given that the trial court found instead of knew or should have known, what are we supposed to do with that, given that we're not the finders of fact?
I think that the court was trying to say that, but I know that's not, that it was implied from the circumstances.
But that's not the language that was
problematic.
used. The language was should have known. And of course, we've got a case that says willful blindness, which is actually stronger than should have known, isn't good enough. So why should we find knew or should have known in this context to be good enough?
Well, I think that in looking at a lot of the cases related to knowledge, many of those relate back to receiving stolen goods and the intent necessary for those, and a lot of those decisions are based on that statutory definition of knowledge.
Is there a different standard of knowledge for aiding and abetting murder than aiding and abetting something else?
Well, I think it matters that there's not a statutory definition of knowledge there as it is with receiving stolen goods. And I would also point out that even the statutory definition in receiving stolen goods has changed over time. Some of the cases cited by the appellant happened before North Carolina General Statute 14-71 was amended. Even it still allows for or having reasonable grounds to believe. That is allowed to constitute knowledge of receiving stolen goods.
Well,
And I believe in essence,
is reasonable grounds to believe good enough in this context?
I believe that it is. I think.
And why do you given that you've emphasized that 14-71.1 is receiving stolen goods, there's no language like that in any case of this court involving aiding and abetting murder, is there?
Well, I point out that just to show that I think that over time, the general requirement for knowledge has been expanded, and I believe that it can be so expanded in this case in aiding and abetting. And I believe that.
So are you asking us to change what the word knowing means in the context where there's not a statutory definition?
I'm asking you to define it as it is defined now, currently defined.
In the receiving stolen goods statute? And make that applicable to everybody in every offense?
Well, I think it can be applicable in this case, that having reasonable grounds to believe could be sufficient in this case, and I think that is essentially the same as should have known. But I think, I agree that that's problematic wording. I wish that the court had not used that wording. I would think that if there's a remedy necessary for that, then remand is the extent of that remedy.
Can I ask you what your view is of the legal significance of the fact that the mother pled guilty to intentional child abuse, inflicting serious injury? And the trial court's order of adjudication, finding number 10, recounts that she was convicted of one count of intentional child abuse, inflicting serious physical injury. Then in its order terminating parental rights, the court says that that they are incorporating herein by reference as if fully set forth herein all of the findings from the adjudication order. If you have a situation where there are further findings that the injuries of the children were not accidental, how is it not, is there anything improper about this ultimately being a showing that there was an assault by the respondent mother, and that meets the statutory definition under 1111(7)(b)(a)(8)?
Well, I can tell you why we didn't plead it that way before the court. We alleged the aiding and abetting, and I could be mistaken about this, because I'm not a criminal lawyer, but my understanding is that there is a difference between serious injury and serious bodily injury when you're charging an assault crime. And so it was my understanding that the intention of 7B1111A8, when it refers to the assault, was that it would have to be what is defined as serious bodily injury. Now, I could be wrong about that, about there being that difference, but I didn't ask, as the trial attorney, I didn't ask the court to find based on that assault, because that was my understanding. So we pled it as an aiding and abetting case, because we were certain, based on the facts in this case, that she had aided and abetted in this murder.
Thank you.
So, and I'll just touch on the expansion of the parental duty under Walden. I think there's an argument, we didn't hear much about it today, but that somehow the passage of 14-5.2 somehow limits or extinguishes the duty in Walden. And I believe that actually the parental duty was expanded in Walden. And in the case of State v. Gaines, this court has said that to the extent that Walden suggested that this parent had to be present in order to be liable for aiding and abetting, then only to that extent would Walden then not be authoritative on that issue. So my reading of that is that after 14-5.2, the parental duty is to take all reasonable steps necessary to protect one's child from abuse, whether or not one is actually present for the final act. And in this case, as a number of you have pointed out, there were many steps that the respondent mother could have taken before her child was ultimately killed. The findings, I think someone mentioned earlier, that she knew how to access the domestic violence protection system. She went to work every day at a restaurant. She had a phone. She could have asked for help day after day after day, and she didn't do that. And I think that in and of itself, especially coupled with all of these other findings, she had reasonable steps that she could have taken to protect her children. She had a mother, by her own admission, who would have helped. But what did she do? She decided not to let that mother see her child so that she could continue to protect her boyfriend and to create an opportunity for these children to be further abused and for John ultimately to be killed. So I don't want to cut into my co-counsel's time, but I would urge this court to affirm the holding of the trial court in this case and to find that this mother is guilty of aiding and abetting in murder. Thank you.
May it please the court, my name is Matt Wunsch. I'm appellate counsel for the Guardian Ad Litem program, and I represent the juvenile Charlie in this case. The court and counsel have already talked through a lot of the issues I think that this case presents, but I want to try to add on a little bit where I can. I want to talk about the precedent that this court has as the best interest of the child being the polar star in child welfare cases. I want to talk a little specifically about aiding and abetting, and I also want to talk about conspiracy, which I don't think has come up in the discussion yet. But the memorandum of additional authority that I sent up early last week, Your Honors, I didn't cite those cases in my brief originally because they're neglect cases, and that's not the ground that we have here. But In re JAM, In re AW, which is a termination case, both center the best interests of the child in similar factual circumstances where you have a mother and a partner, and it appears that the partner is the primary perpetrator of abuse on the child. AW, in fact, there was a prior death, and so they're very similar factually. And I just asked the court to look at those cases with that in mind. I realize that they're not addressed to the A8 ground that we're dealing with in this case, but I think their discussion of these kind of circumstances is very relevant to this case. So the court, I think, has discussed Walden and some of the implications of that case already. I wanted to Justice Hudson's question about the language of Walden and whether it's a broad holding or it's narrowly confined, just to the circumstances of that case. I think the language of Walden is very broad, and that was why I cited the Dittenhafer case in my brief, because I think that's a natural extension, Justice Irvin, your dissent in that case, of that logic from Walden, that a parent, even who isn't present, has that duty to protect her child.
Well, but as you indicated, my separate opinion in that case was a dissent and not the majority. And so what implications, if any, are there for this case in the majority's opinion in Dittenhafer?
Your Honor, absolutely. So the majority opinion really, I think, is grounded in the fact that it's a criminal case and there's an indictment that doesn't specifically allege some of the circumstances necessary to support a conviction. And I think that's what distinguishes the majority's opinion from this case. And I realize that the dissent is not controlling authority, but I think it's persuasive authority on this point, that this duty, again, to Justice Hudson's point, is broad. And as Walden itself points out, it's not necessarily, or it wouldn't be fair to ask a parent to intervene in, say, a life-threatening situation for themselves. It might be what we all hope we would do, but it isn't necessarily fair to make that a legal obligation. But it is exactly addressed to the circumstances we have here, where a parent is leaving the house, as Ms. Vaughn pointed out, going to work, has access to domestic violence networks where she could obtain help for what is obviously a serious situation going on in the home.
Does it make any difference that Dietenhofer was an accessory before the fact case? This is an aiding and abetting case?
Well, I think the principle is the same, Your Honor. I don't think we're citing it for this, it is exact controlling, on all fours authority for this particular case, but I think the principle is the same, that a parent does have a duty, and we'd argue that it's a broader duty than just confined to that particular offense or those particular circumstances, and that in fact it's good policy. It's not just in our child welfare law, but in our criminal law, that we want systems that encourage parents to take action when they can, when it's safe for them to do so, when they have the opportunity to do so. We want them to be encouraged to do so. I feel comfortable representing the GAL program and advocating for that. The Miller case, Justice Ervin, that you were asking about, and sort of the line of cases off of that this difference between knowing and should have known. And there is, as Ms. Vaughn acknowledged, that language is not ideal. I think we agree on that. But there are a couple of initial or additional distinctions that I would draw. One is this, again, it's not a criminal case where we're operating under a clear and convincing evidence standard, not a beyond a reasonable doubt standard. So I think there's some distinction to be drawn there.
How does that, given the typical criminal case, we've got instructions given to a jury in the return of a single verdict, whereas here we've got findings by the trial court, and ultimately what we've got to do on review is to look at the findings and see if they're sufficient to support the conclusion that the trial court reaches. How does the fact that this is not a criminal case really have much bearing upon whether the finding knew or should have known is problematic?
Thank you, Justice Ervin. I think that's another important distinction, is that these cases that talk about this excess language are typically jury instruction cases. And so a jury is instructed by the trial court, known or should have known, and that's not accurate to what the law is. And then we get a verdict back from a jury that unless they're polled or there is something on the verdict sheet that indicates which theory they took, we don't know what supported that verdict. And so there's a unanimity issue in a criminal case with jury instructions. We don't have that here.
Well, how do we know the trial court said no or should have done? How do we know what the trial court actually found?
I think to Ms. Vaughn's point, we look at the other findings of fact, and they all point in one direction, that mother saw what was happening in the home, mother left the children knowing what was happening in the home. In fact, I think this was to Justice Earle's point, finding of fact 60 talks about mother's own role in potentially in that abuse, which was incorporated into the trial court's termination order as well. So we have lots of other findings. Unlike a jury who is sort of a black box that just produces a verdict, we can see the trial court's reasoning play out in the rest of the order here. We know from context what the trial court found, that it found the circumstances show that the mother knew. And I would say that, or should have known, at most indicates an extent of imputed or implied knowledge. It's not actually should have known in the sense that it may sound in a criminal instruction. It's not a reasonable person. It's that, in fact, based on all of these other findings that I made, it's clear that she knew, even without direct evidence of her acknowledging it.
So if you look at the second sentence of finding of fact 13, the court seems to be either explaining or qualifying the first sentence, which has the knew or should have known language, where it says actions, omissions, and decisions of the respondent mother created the opportunity for the boyfriend to commit the murder and were tantamount to consent to the conduct. How are we to use that language as we seek to understand the first sentence, or is this the court just saying it in a different way, what the court intended in the first sentence?
You're right, Chief Justice, I would read it the way you just explained it, that it's further explanation of that initial knew or should have known. And just as the other findings show us what the trial court actually believed happened, which is that the mother knew what was going on and left the child, or children, I keep saying child, children in this situation. Here are all the things that she did or didn't do that show knowledge and culpability. So absolutely, Your Honor, that is how I would propose reading that finding. It's clarification of that phrase.
How, if at all, do we deal with findings in the adjudication order that seem to specifically say knowledge on her part?
I'm sorry, Your Honor, that say that she did have knowledge?
Yeah. Do we consider that at this point?
From the 2013 adjudication?
No, this is from the 2020 adjudication.
Oh. Well, certainly, I think those support any finding that says that she had knowledge supports a conclusion that she aided and abetted. Those findings support the outcome here. In fact, I would argue that they support conspiracy as well, which just requires a meeting of the minds. You know, I think particularly in a second-degree murder case, we have a conviction of the boyfriend for second-degree murder. We know it's a malice murder. It's not a premeditated, deliberated murder. It's something so horribly negligent, done with malice, that leads to the death of the victim. We have the mother here, again, knowing what's going on in the home beforehand, leaving the children there. Then after the fact, after John had suffered all of these horrible injuries, not seeking out help, in fact, changing plans, keeping the children away from people that might have helped them. Just as in any other conspiracy case, we don't typically have direct evidence of an agreement. It's from the circumstances that agreements typically are inferred. And in fact, what a defendant does after the commission of the crime, say steps to cover up the crime, are typically very strong evidence of a conspiracy.
So finding of fact 35 says the presumed cause of death for the minor child was determined to be drowning with significant contributory factor of burns and blunt force injuries. I interpret that to mean that while the child may have died in a bathtub, the child would not have drowned in the bathtub if the child had not previously experienced the burns and the blunt force injuries. In other words, this child was so depleted of energy because of those injuries that the child could not defend its or survive in a bathtub because it's lethargic, a significant lethargy. Am I reading that correctly?
I believe so, Your Honor, and I believe there are numerous findings throughout both that initial adjudication order and then the termination of parental rights order that support that reading. The other thing I'd refer the court to, and I'm sure that the court has looked at this already, but there are photographs in the record that start on page 277 that are very difficult to look at, but I think they're very important to look at, and especially in the context where we're trying to figure out knowledge and whether there is any level of plausible deniability of knowledge of what was going on in this home. I think that those photographs put that to bed definitively.
I know your time is taken away. I'll be very quick. You mentioned conspiracy in your brief. You talked about it just a bit ago. A8 talks about these criminal aspects, aiding, abetting, attempt, conspiracy, as you mentioned, solicitation. Are you saying that we are authorized to extrapolate from these crimes as they're contemplated in their usage in A8 in a civil context, aiding and abetting, or conspiracy, or some other theory upon which to say that the respondent mother is responsible here for the death of John?
I believe that's what the ground requires, Your Honor, is that and we have this intersection occasionally in child welfare law where statutes from the criminal code are being applied in a child welfare case. And so I think it brings up an important point that just to keep in mind that this, again, it's under the standard for a child welfare case. So it's not a beyond a reasonable doubt application of the elements of those offenses, but it is taking the elements of those offenses and seeing whether the trial court found them by clear and convincing evidence.
But is that the bridge, the fact that it's clear and convincing as compared to beyond a reasonable doubt?
Well, I don't, Your Honor, in this case, I don't personally think that it would make a difference. I would be comfortable calling the evidence and the findings we have beyond a reasonable doubt. But it is a lower standard of evidence in a child welfare case. I see my time has expired, but thank you.
Thank you, counsel.
We respectfully ask you to affirm.
Thank you, counsel. Rebuttal.
I only have a couple of minutes, but for this court to look at and maybe you all to discuss, there's a difference between accessory before the fact and aiding and abetting. If you're an accessory before the fact, the person does something before the crime is committed, and somebody else does the crime. The cases Claypool and Reffin both are accessory before the fact cases. In those cases, the principle in accessory before the fact is that if you're accessory before the fact, you're responsible for everything foreseeable. Everything that foreseeably happens, you're responsible for, which is kind of the argument they're making. That's not the same as aiding and abetting. It's a different theory. And just looking at A8, it's noticeably absent that accessory before or after the fact is not listed in A8. So you're taking principles from a different theory and trying to apply them to aiding and abetting, which I think is inappropriate. The good test that was established after the change of the statute is what this court has held as the standard. To aid and abet, to be a participant in crime, you have to know what's going to happen. The other thing, I know they had mentioned best interest. I would say, if you look at the transcript, my client was convicted. She went to jail. She went out. She gave birth to Charlie. They entered into a safety plan. After entering into a safety plan, she lived with the paternal grandparents, supervised. DSS didn't have a problem with her living there with the child. The paternal grandparents said that she was doing everything as a parent. Under this, and this is a consolidated appeal, which is unusual, right? Because we're doing the termination along with the appeal with the underlying juvenile case. I didn't challenge the neglect case. DSS, even if you rule in my favor, is still going to be involved. But you're taking something that was 6 years between here and the hearing. We're now at 7. I think the evidence shows that she's changed. I respectfully submit that. Thank you. If there's no other questions.
Thank you, counsel. Madam Clerk.
Hey, good job.